I don't know. All rise. Hear ye, hear ye, the Honorable Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Well, I want to welcome all of you to today's arguments. This is a little larger crowd than we're accustomed to hosting in Lansing, and we are happy that you could all attend. Before I call today's case, I'd like to note that this marks the first time that our colleague Justice Joan Larson will be with us for the Court Community Connections Program. This will be, however, her 12th oral argument this month. We also want to welcome all of the area students and educators and our hosts. And thanks also to the Bar Association attorney mentors and to the attorneys who will argue this case, Randy Price and Peter John Van Hoek. The students in the courtroom represent Allegan, Bangor, Berrien Springs, Bloomingdale, Covert, Decatur, Gobles, Hartford, Lawrence, Lawton, Marcellus, Matawan, Pawpaw, Sagatuck, South Haven, and Van Buren Intermediate School District. I want to talk about a couple housekeeping items, with the exception of the media and the professional photographers. No one is permitted to take photos once oral argument commences. And that's important for both counsel and the court to minimize disruptions. There will be plenty of opportunities for photos during the reception. Also, if you have not already done so, please take out your cell phone and put it on stun now. Everybody's done that, right? I'm waiting to hear it go off during the argument. Also, if you following oral argument, please remain in the courtroom for the debriefing with counsel for the parties, and our Supreme Court General Counsel, Joe Bowman, will moderate that. It's been a wonderful opportunity for the students to ask questions of the attorneys about the things that they saw happen during the oral argument. This Court Community Connections program was created to give you an up-close look at the Supreme Court. And we often have schools come to Lansing to see the court. Today we've come to you. There are many depictions of trial courts in our media and in the arts, but very few of appellate courts. We do not hear new evidence or testimony. We rely on the record made in the initial trial court to determine whether an error of law has been made is of such significance that a different outcome is warranted. An oral argument is a key part of the appellate decision-making process and can determine not only the outcome for the parties in this case, but can affect the outcome of future cases that lower courts will be bound to follow. By the time of oral argument, we justices are very familiar with the case. We've read the parties' briefs and parts of the lower court record and have studied the legal issues. The questions we ask during oral argument and counsel's answers do help us to reach a decision, but more importantly, they can help us, if we render an opinion in this case, to craft a clear and accurate statement of the law. Like us, you have already studied this case. You know what the issues are. You have come to today's hearing with questions you would ask if you were one of us. And sometime from now, when the court issues its decision, you'll get to analyze our ruling and decide whether you agree or would have done things differently, and why. So our goal here is to leave you better informed about the rule of law and its role in our constitutional republic. My hope is that as a citizen of your community, you will remember this experience. Our form of government can only survive if its citizens stay informed and involved. And with that, I will call the case, but let me remind the advocates that this is an argument on application. Each side is entitled to 15 minutes per side, the first 2 minutes of which come to you uninterrupted by questions from the court. As I said to the students, we've read your briefs. I encourage you to get to the outcome determinative questions as quickly as possible. And the case is, People versus White.
May it please the court, Peter John Van Hoek on behalf of the defendant appellant Stephanie White. I'll waive the free fire zone, so I welcome any questions your honors have. I'd like to reserve with this short argument only 1 minute for rebuttal. Like many cases that seem complicated at first, this case comes down to what is essentially a fairly simple question. How do you prove where someone lives? How do you prove their residence? Here, the question is whether the prosecution presented sufficient evidence under the constitutional standard that Stephen White, the 22-year-old adult son of my client Stephanie White, lived at the house that was entered by Officer Green.
Okay, well, since you invited it, I'm going to start right in. Isn't it actually whether they presented sufficient evidence, whether the officer reasonably believed, assuming that's the standard, just play with me
Yes.
for a minute, that he lived there? It doesn't have to be correct, just that he reasonably believed it.
Well, it doesn't have to technically be correct if it's a reasonable belief.
Right.
But two answers to that, and I'll talk about whether it was reasonable in this case. But one thing I think is very clear that this court should recognize in this particular case, Officer Green never testified he believed Stephen White lived at the house.
I give you that. I read the testimony.
Yeah.
That's
So
true.
the question of whether he was reasonable and reasonable belief, we don't even know what his beliefs are. I think when you read the testimony, it appears much more likely that Officer Green believed the existence of the arrest warrants allowed him to enter any house in which Stephen White was
That's how it
presently-
reads, but we're in this weird position as a reviewing court on a sufficiency question,
Yes.
trying to put together, we're basically putting Humpty Dumpty back together again post hoc, using what we have. We don't have any deference to give to any fact finder because it seems everybody in the trial court didn't understand what the legal standard was, so
correct.
it wasn't sort of directly addressed.
No.
So we get to pick and choose, and we have to do it in a light most favorable to the prosecution, I think you would agree.
Yes.
Whether a reasonable jury could have found that there was no reasonable belief that he lived there. So he went there for some reason, and there was that address on one of the warrants.
Correct.
And he had experience with Stephen there before.
Correct.
Is that not enough to sufficiently show that he had a reasonable belief that Stephen lived there?
No.
I thought you might say that.
If I said yes, I'd be sitting down. No. Let me talk about why it wasn't reasonable. When the police have a warrant, and they need constitutionally just an arrest warrant, not a search warrant, for them to believe that they can enter a particular residence on the basis of just an arrest warrant, as you said, they have to have a reasonable belief that that residence, in fact, is occupied or belongs to the person named in the warrant.
Right.
Officer Green, whose job it was to execute warrants, on his lien showed 5 existing warrants for Stephen White. 4 of those warrants listed,
2 of them, were they not related to the incident at this residence, right?
it appears that one of them was related to a domestic dispute between Mr. White and his girlfriend that occurred at his mother's house.
And the second related to that incident was what?
Well, the warrants were basically for failure to appear. The one warrant that listed that address was the actual warrant for arrest for the domestic domestic assault or that allegation. Some of the other warrants were for failure to appear on other things.
If you put together the pieces, oh, sorry, go ahead, Justice.
Oh, well, I was just going to ask, so those prior bench warrants would have been related to where he lived on some prior occasion, correct? But when he, during that involvement with the criminal justice system,
Well,
and this one post-dated those, is that correct?
No. Well, number one, I suspect that particularly in the district court, when an officer comes in to swear out a warrant and they ask for the address to list on the warrant, there's not much consideration given to whether that's an accurate address or not, number one, okay? Number two, because I don't think officers come in to swear out a warrant and they're talking about the address versus the circumstances of the alleged offense.
Right.
But even so, even if that's the case, 5 warrants here, 4 list a different address, the same address but a different address than Ms. White's. 1 lists this address. That was not the most recent. The most recently filed warrant was one of the 4 that listed the other address in Saginaw. Okay. So the officer, if you're going to go on the most recent warrant, would have gone to the other house, not to this one.
Is it your position you can only have one residence?
No.
Well, okay. Now, why then must we assume that the most recent warrant address is the only place the guy resided?
The point of being reasonable, however, is an officer looking at 5 warrants, 4 of which list one address, including the most recent, 1 of which lists a different address, an address he knows belongs to my client, the mother, should,
Wait a minute. How do you know he knows it belongs to your client's mother?
because he's been there before and
I
dealt
know
with the
that,
family.
but he's been there at the very time the defendant's son was there.
Exactly. Doesn't mean he lives there, it means he was there.
Well,
The question of whether Mr. White, in our briefs, there's some discussion about, from the prosecution side, about whether there's reasonable cause to believe Mr. White was there at the time. We don't dispute that. He looked in the window and saw him. He knew him. So that's
right,
not an issue.
Okay. Now, we're talking about whether it was reasonable
Yes.
to believe that the defendant's son resided there.
Yes, yes,
Okay.
okay. But when an officer, I think reasonably when an officer sees that situation, where it's an 80% chance that the residence of Stephen White, an adult, is at a different location than his mother's house, should take steps to try to confirm where, in fact, Stephen White lives. Now, he could live in both houses, true. But there's no evidence in this case presented by the prosecution that Stephen White lives in both houses, let alone that he lives in this house. That's why I cited to the Sixth Circuit case in Shaw. And I think Shaw is really important here because it's a very similar situation.
It isn't. Let me suggest why I think Shaw might be different. Shaw involved the situation where the police affirmatively represented to the homeowner that they had a search warrant for that house. That seems to be the significant
No,
factor.
they did not say they had a search warrant. They said they had an arrest warrant. But they didn't have a search warrant.
Okay.
They had an arrest warrant. In Shaw, they have an arrest warrant for a particular woman. There's an address on that warrant. They get to the street, and no house on that street has that address. But houses on opposite each other, on opposite streets, have the same address. Obviously, some sort of confusion there. The police officers at that point decide, well, we don't know which is the right house. But they see one house has lights on and one house is dark. So they go to the house that has lights on, they knock on the door. A woman answers, they think it might be the woman they're looking for, and they falsely tell her, we have a warrant for this
For
house.
this house, right.
Yeah. But they didn't have a search warrant, they had an arrest warrant,
Counsel,
which is important, because they had a search warrant, it wouldn't matter.
Counsel, in the United States,
But- Excuse me.
in Maryland versus Bowie, the United States Supreme Court said the question is whether the searching officer possesses a reasonable belief as to the questions at issue. Did I understand you to suggest that this necessarily presupposes a subjective standard, or is that not an objective standard?
Well, I'd say to be an object. I think that the officers, if he had in fact testified that he believed Stephen White lived there, that would be a relevant subjective fact in this case. But a reasonable belief tends to be an objective standard.
But we're not trying to read his mind, are we, and determine what his
No.
personal predilections or eccentricities might have been?
if
We're
he-
looking at this objectively, right?
It's an objective test. The reasonable test is usually an objective test. If he had said, I believe Stephen White lives on Mars, you wouldn't take it and give it much credence. I mean, his subjective belief really isn't the point. What I'm arguing is that an objective police officer, any police officer, looking at these circumstances, 5 warrants, 4 listing one address, 1 listing a different address, the most recent one listing a different address, in order to reach a reasonable conclusion that Mr. White lives in the one address, would have had to done something further to try to confirm where Stephen White lives. And as I said, go back to Shaw, it's 50-50. They end up going to the wrong house. The person named in the warrant lives across the street. They go to the wrong house, and they come up and argue, isn't it reasonable that one of these 2 houses was the right house?
Well,
And
this-
it was
this-
50-50, and we went to the wrong house. It was
Aren't
an
you
honest
Aren't you
mistake.
confusing a probable cause standard with a reasonable belief standard?
No.
Why isn't it reasonable, at least in part, to believe that if you recurrently see the same individual at a home, that maybe that's in fact where he lives?
Well, if you know the family, you know this is
I
an
mean, it's
adult
something
son.
less than probable cause you would agree that's required here, is there not?
Well, it's a dispute between the cases, as I've talked about.
Well,
Some
how do
cases
we
hold
resolve
probable
that
cause.
dispute?
I don't think it's necessary for this court to make that decision, just like the Sixth Circuit and Hardin didn't have to make that decision, because I think the defense went on either standard, probable cause or reasonable belief. What I'm saying, now, let me go back to Shaw. When they say it was reasonable for the police officers to pick one of the 2 houses and go up to it, even though it was a mistake, and the mistake really was made by the people that put the numbers on the houses, not them so much. They argued that. It's reasonable. It's 50-50. What's wrong with that? And the Sixth Circuit said no. And this is the last sentence, as I quote on page 12, they say, that is all the more true when there are readily available means for alleviating most, if not all, doubt about the point, and when no officer safety concerns justify the deception.
But that's because, as I read Shaw, they were very concerned about the misrepresentation. The officers, in short and in truth, had no right to enter the house based on a falsity,
Right, because,
and no right to stay there based on the falsity. That's the sting of this case.
Well, no.
Not the fact that they did 50-50.
I don't agree, because in Shaw, the court had to deal with the fact that when the officers went to the door and knocked and said, we have a warrant, the woman let them in, and they had to deal with the question of consent. They had to deal with, and they said, you can't get consent by falsely stating you have a warrant. But we don't have consent in this case.
I think that we're not in disagreement
Yeah.
about what was animating the Shaw court. I just think it's distinguishable. There was no misrepresentation here to gain entry.
Well, not to gain entry, but once my client's convicted of resisting and obstructing. She's in her living room when a uniformed police officer walks through her back door and walks into her living room. She says, what are you doing here? He says, I have a warrant for your son. She says, my son doesn't live here. Where's your search warrant? He says, I don't need a search warrant. I have an arrest warrant for your son. That's a misrepresentation if Stephen White does not live in that house. That's the misrepresentation.
Well,
He
it's
tells
not,
you,
no.
you can't stop me.
Counsel, it's not a misrepresentation if, in fact, he had a reasonable belief that she was lying and he, in fact, lived there.
Well, number one, he never said he had any reasonable belief that Stephen lived there, let alone her lying about it. I mean, I think you read the record, I don't think he believed it didn't matter to him whether Stephen White lived there or not. He thought he had an arrest warrant. He saw Stephen White. He thought he's justified for entering the house to try to arrest Stephen White, regardless of where Stephen White lived. So that's not, there's no records that support of that.
So is your position that the officer would need to testify in every case in order to be able to, for the prosecutor to get a conviction in an obstruction case like this?
Well, when the defense is an illegal entry, and that you needed a, yes, I think a prosecutor should ask the police officer, why did you go in that house without a search warrant? And he says, because for these reasons, I believed the person named on the warrant lived here.
But absent that testimony, you think a conviction can never stand?
No, I think you have to look at all the facts and see what's reasonable or not, even if they don't say that. And in this case, I don't think it's reasonable for Officer Green to enter a house that's named in 1 out of 5 warrants without taking steps ahead of time, which the
Would you,
Shaw Court talks
counsel?
about, of trying to confirm whether he lived there or not. And it's
Counsel?
easily done.
Would you like to reserve any time?
Yes.
He said a minute. I'd like to follow up with one quick question.
Yes.
And I'm not trying to get you to run out your time, but Justice McCormick asked you at the outset a question that I'm very interested in, and you were just assessing the evidence from your own perspective. And my question to you is, shouldn't we, this case comes to us not on the usual course, right, or the usual method. We don't have a motion to suppress or some other legal challenge that was leveled either at the jury instruction or in some other way for us to review the evidence in the way that we ordinarily would and make the assessment that you're inviting us to. So that the question is, in a sufficiency challenge, and particularly after Marino, which instructs that this is an issue of fact for the jury, and now we're looking at it in the light most favorable to the people, the evidence that came into this case. Aren't we doing something different in this case than most of the other cases that you've cited?
No. In any sufficiency case, it could be raised for the first time on appeal. This isn't a motion to this isn't a suppressive evidence.
That's not my point.
Well,
The point is, aren't we just looking to see whether there's evidence that's sufficient for the jury, taken in the light most favorable to the people, for the jury to reach the conclusion it reached, even if it's a different conclusion than I would reach or than you would reach?
Oh, yes. I don't think it's not a question of whether you agree or disagree with the jury verdict. I mean, number one, the jury was not adequately instructed here that they had to find that there was a reasonable belief that they lived there. No one even talked about this at trial. They were instructed on the elements of the offense, and the elements require there be a legal entry into the house before you can be convicted of resisting or obstructing. That's an element the prosecution had to prove beyond a reasonable doubt under Marino. My argument is, in this case, is no different than any sufficiency argument. Elements normally are a fact question for the jury, but if there's insufficient evidence constitutionally to present that fact question to the jury, even in the light most favorable to the prosecution, this court certainly has the authority and the duty to rule on that. This is no different than any other sufficiency argument.
But
My
that's my
argument
question
that
is what's our job? It's such a weird sufficiency argument in a way, because usually we're deferring to the jury on, or the fact finder on, credibility, on weight, and here there's nothing to defer to. So does that help the prosecutor or hurt him? I mean, because I agree with you, when you read the whole transcript, it sounds like everybody believed, even through the trial, except the defendant. The defendant seems to be the only person who knew the law in the whole case. But apart from her,
Yes.
everybody believed that if you have an arrest warrant and you see the person, that's good enough. You can go get them. And so you can tell from the summations and from the instructions, nobody understood that the jury needed to hear that the officer had a reasonable belief that the defendant lived there. And now we have a sufficiency challenge when this issue was not really put into issue at the trial. So as a reviewing court, do I just pick and choose the evidence that might be there that could have led to the officer to say, I reasonably believed he lived there. I'd seen him there before. The address was on one of the warrants. I knew his mom, said he sometimes lived there. Do I get to do that, or do I have some other job in this weird challenge?
Well, the jury did decide. The jury was read the elements. So the jury was told they had to decide that the officer was acting lawfully before there could be resisting and
But
obstruction.
they
But
were
they weren't given that. They weren't
They were
given enough evidence.
instructed that it wasn't what he did and believed was in fact legal. Your predecessor at trial stipulated to a jury instruction that said if he was effectuating an arrest warrant, he had a right, and saw the defendant, he had a right to be there, right?
So they took this issue out of the jury's deliberation?
I don't think no, I mean.
Was that, first, do you acknowledge that that instruction was given?
I acknowledge the judge said it's legal to enter a house on an arrest warrant. However, that's an incomplete instruction, because sometimes it is and sometimes it isn't.
I understand it may be incomplete, but that's what the instruction
Yes,
defense counsel permitted the jury to hear.
Yes.
It was an incorrect, I believe, statement of the law.
yes.
So how does the incorrect instruction, which was approved twice by defense counsel, affect our review of the sufficiency? Because they were instructed that they didn't have to consider his belief about the legitimacy of entry. He was instructed he was legitimate in acting on entry because he had a warrant.
So does the Supreme Court make it up for the first time? Like,
Make up what?
whether the evidence was sufficient on something nobody ever
No,
considered?
no, I don't. I think the fact that the instruction here was incomplete and maybe inaccurate doesn't change the sufficiency review, because this court knows what the law is under Marino. Marino, they have to prove the legality
Is
of
there
it.
a
Whether or not
waiver?
there's
I'm asking, essentially, does that instruction constitute a waiver of the sufficiency argument?
No, I don't think you ever waive sufficiency. I don't know how that can be waived. It doesn't even have to be raised in the trial court, so I don't see how it would ever be waived. Every time this court or any appellate court looks at sufficiency, they look at what the law is, what the law requires, and they review the evidence in a light most favorable to the prosecution and see whether it presented a constitutionally sufficient question of fact to the jury. That's my argument here. I mean, I think there should have been a better instruction, but I think even with a correct instruction, it still wins under sufficiency. It isn't the error, because this court when you argue sufficiency, you don't give, when you find a case constitutionally insufficient, you not only don't give deference to the jury's fact finding, you overrule it. So the fact that the jury found that this was legal because the judge told them it was legal doesn't mean that it passes constitutional muster.
I know, I'm still just struggling with, we review it, though, in a light most favorable to the prosecution, and it's hard to review it when nobody actually addressed it directly at trial. So we're kind of picking and pulling different
Well,
pieces
again,
of it to...
I think if we were talking about a bad jury instruction or waiver or something like that or whatever, that's one thing. But as I said, we have insufficiency all the time in a case where there's no motion for directed verdict. There's no I mean, you've got the elements, you've got the law, you've got the facts, and you review it. And you say, was it sufficient or not? Did they leave out something? Is it enough?
I'm not arguing you waived it. I'm asking whether the fact that it
Okay.
wasn't really squarely addressed because nobody understood that it was the actual law ends up helping the prosecution, because we get to just, does it leave me in the fun position of being a juror myself and finding things that I think would have made for a reasonable belief?
Well, in a sense, anytime you argue sufficiency, you're looking at it like from what are the facts are and what do you have enough to meet the Jackson versus Virginia standard, not the old any. Sure, under the any evidence standard, this would have been enough because there's one warrant out there. But under the Jackson versus Virginia standard, which requires more than any evidence, was this enough to make it reasonable for this officer, if he in fact believed that, to believe that? I say no, because a reasonable police officer, like in Shaw talks about, a reasonable police officer objectively seeing this discrepancy, seeing 4 references to one address, including the most recent, and 1 reference to a different address, before entering a house, if he knew the law, would have said, I'd better find out. I don't know where he lives, so let's find out. Let's talk to the tax people. Let's talk to the post office. Let's do the kinds of things I talked about in constructive possession cases. How do you prove where somebody lives? If they don't admit it, you use circumstantial evidence.
I
Is
understand.
there
Sorry,
did they make any effort? No. All the police officer had to do is make a little bit of effort.
I think
try
we
to find
understand
out.
your argument. Thank you.
Okay, thank you.
Chief Justice, Justices of the Court, may it please the Court. My name is Randy Price on behalf of the plaintiff appellee, and I ask this Court to find that the officer, Officer Green, did lawfully enter the defendant's home when he attempted to arrest her son, and she resisted and obstructed the officer's attempts. And I also ask this Court to affirm her conviction for resisting and obstructing a police officer. The main issue here is whether the officer had a reasonable belief that the defendant's son, Stephen White, lived at that address, 2855 Germain Drive. And the answer is yes, if you look at a rationally drawn, the reasonable belief here, a common sense evaluation of the circumstances. And we have 4 things here that the officer knew. 1, he had been at that house before and had contacts with Stephen White. 2, when he knocked on the door, who answered the knock? Stephen White, the son. And I think that the officer could reasonably infer that if someone's answering the door, that is their residence. 3 is the arrest warrant. I believe the officer could reasonably rely on the arrest warrant to have the Stephen White's correct address to go to that house. And 4th, again, his presence in the house verified that that was his address. I believe that this, as most circuits use, is the reasonable belief standard. Only one, it was the Ninth Circuit, uses probable cause, but I believe reasonable belief is the proper one based on Payton versus New York uses reason to believe language in that case. There was some question or responses regarding the last warrant that was part of those warrants that the officer viewed. The last warrant was regarding a failing to appear in court for a pre-sentence investigation report. So that case occurred way before the arrest warrant that the officer used to go to 2855 Germain. And the arrest warrant that he relied on was just a month, less than a month from the day of the occurrence, which was September 5th, 2012.
You want to...
I was, there are a number of us who've expressed perplexity about how to resolve a case in which it was quite apparent that the two advocates and the court failed to understand what the legal standard was. That's evident in the erroneous jury instruction opposing counsel conceded was given to the jury about what had to be proven to establish the legality of the arrest of the defendant. The issue then is at trial, therefore, it's not surprising that there were no proofs on the first element of this burden to show that there was a reasonable belief about the residence of the defendant's son. So I'm struggling as some of my colleagues are to figure out, well, if the parties didn't think they had to prove it and they didn't, how do I get to gap fill here?
I would say that it's a question of law that should have been answered before it got to the jury or got to trial. I don't think it's a question of fact for the jury to determine whether the officer had a reasonable belief to enter the home to arrest the son.
But they weren't instructed on that. Nobody thought
No.
they had that obligation to make that. The officer didn't, in fact, testify
No.
that he even had the subjective, much less the objective belief. Nobody even argued it to the
Correct.
I mean, we're still, when you read the officer's testimony, it sounds like he didn't believe he lived there. He believed he might find him there, which in fact he almost did, except the guy ran away fast enough. But when you read the back and forth, I mean, he says to the mom, I'm here because I have an arrest warrant for your son. She says, my son doesn't live here. You need a search warrant. He says, no, I don't. I have an arrest warrant. I mean, it's clear he doesn't seem to believe he needs to show during the trial. Now, he might well have been able to, right? He had been there before and interacted with the kid before. He had that address on at least one of the warrants. I understand there was one after it that had the other address. And like you said, he answered the door. So he may have all of those might well form the basis for a reasonable belief. But we're reviewing it for sufficiency, and none of those dots were connected in the trial record. Not the officer's fault. He wasn't prepared particularly well for this testimony. But do we get to connect those dots because it's in the light most favorable to the prosecution, and can we connect them such to find that it was proven beyond a reasonable doubt?
Yes, and I believe the reason that the assistant prosecutor asked the officer about the arrest warrants being to the house before, identifying Stephen White in the past, was to show that the officer was lawful when he entered the home, that there was no violation of the defendant's Fourth Amendment rights. This was not an illegal search and seizure. And I don't think this is a sufficiency of the evidence argument that you have to show that the officer was lawful. I think this goes to a question of law, just like with a motion to suppress at a Walker hearing to determine whether the suspect was there on his own volition, that he wasn't forced into making a confession or something to that effect. And maybe that what the defense attorney should have done is brought a motion to suppress or to exclude the evidence that the officer was not lawful in the house. And I think what you alluded to, Justice, was maybe whether the officer had a subjective or objective belief, but reasonable belief is not using subjective or subjectivity, but objectivity, looking at...
Yeah, no, but when you read the cases, the officer has to have had a belief that we then judge to be objectively reasonable. In this case, when you read the transcript, it doesn't sound like he necessarily believed that Stephen lived there. So what do I do with that?
I respectfully disagree. I believe he had enough evidence to go to the house. And I would like to focus on the arrest warrant. When someone is arrested, the officer doesn't rely on, okay, he was arrested at this place, so I'm going to use this as his address. I'm sure the officer either looked at his driver's license or said, where do you live? 2855 Germain. There was another address, and it's not of the record, but that could have been in another jurisdiction that the officer, police agency doesn't cover. But he's been to that house before. He knows that Stephen White could live at that address.
Well, he knows his mom lives there, and he's apparently dealt with the mom a number of times when Stephen White wasn't there. And, we don't know. All this conjecture feels like not very Supreme Court-y to me. I feel like I'm doing something I shouldn't be doing.
No question, the officer, there's enough evidence in this record that would lead the officer to a reasonable belief he could find the defendant at this residence. What strikes me as missing is the basis to conclude that he had a reasonable belief that he lived there. Anybody who has adult children who've moved out knows that they periodically return, and you might find an adult child who no longer resides there in the home at a particular point. It doesn't make them a resident of the home, does it?
No.
Okay,
But-
well, why then do we get to gap fill the fact that this adult child was frequently present in his mother's home, that the officer had a reasonable belief that he lived there? Where is that part of the evidence that I can look to and say, okay, he had prior contacts, even at this residence, the mother had called him about this. There was one of the arrest warrants concerned an event located at this residence. All those point to physical presence of the defendant's son there. It's the next step that he lived there. Where do I find that, and where do I gap fill to get there?
If you're saying residence means that's where you live,
At least one of the places.
Yes. The officer, and I believe the officer had a reasonable belief that that's Stephen White's residence. It's because.
Why?
But, yeah, how do we know that? He didn't testify to that. He wasn't asked that question at trial. He didn't testify, yes, when I entered the home, I believed that Stephen White lived there. So how do we get there as a reviewing court?
I think the court may be looking at, you need concrete proof that that is his residence.
That's the standard.
No, that's the officer's belief.
And I disagree, Your Honor. I believe it's a reasonable belief. It's not that it's
Right.
true in fact.
Right, I'm not suggesting otherwise. The standard requires us to conclude that he had a reasonable belief about one thing now at this point, that the defendant's son lived there. That's the missing piece that I'm struggling with. Why do I get to, as I said, everything points to the fact this officer had a reasonable belief he could find the defendant's son there. I'm just not sure I can conclude that a reasonable juror would conclude that the officer had a reasonable belief that the son lived there. That's the piece I'd like you to address.
When citing U.S. versus Pruitt, they define reasonable belief as a common sense evaluation of the circumstances presented.
Got it. Now,
And-
how do I apply the common sense of the totality of the circumstances to conclude that this officer could reasonably have believed the defendant's son lived there?
The officer in the past, and the 4 points that I mentioned, the officer in the past had been to that home. He testified, I'd been to that home a couple times dealing with the son and his girlfriend. He knocks on the door. Lo and behold, Mr. White answers the door as if it's
son.
his own. Correct. Third was that the arrest warrant had the address of 2855 Germain, the defendant's address, as Stephen White's address. And four is that the actual presence of Mr. White in the house verified that that was his home. Those four things, looking at the totality of the circumstances, equals a reasonable belief in the officer's mind, or I shouldn't say that, objectively, it was a reasonable belief that the defendant, or excuse me, Mr. White lived at that address.
Well, counsel, you agreed with the Chief Justice a few minutes ago when he said, why can't we recognize or take into consideration that adult children often go back to visit their parents? Why can't equally we take into account and give recognition to the fact that adult children often go back to their parents and live at their homes? Maybe
We call that re-nesting.
That is correct.
Well, let me just finish my question. Related to that question is, what does it mean to reside at one's home? If I was to go into the state of Ohio later this afternoon, I would be considered a resident of that state immediately upon crossing into the state boundaries of Ohio. What is it that gives residence to an individual who goes back to his parents' home? Is it the fact that he slept there 2 times in the last month? Is it the fact that he intends to sleep there tonight? Is it the fact that he slept there yesterday? In other words, if we can assume the second presumption, that sometimes adult children do sleep at their parents' homes, more than, say, strangers, for example, what is it that triggers the actual living in one's parents' home? There doesn't have to be 30 consecutive days, for example, of residence in order to trigger that, is there?
No, it could be something as simple as putting on your address or telling a police officer, I live at 2855 Germain Drive, just as this Mr. White did in this case.
Where is that in the record?
Well, it's, there was no testimony, but you can infer from the arrest warrant that, where did the officer get the address? He got it from...
You've been there.
Correct. But when this Mr. White was arrested for domestic violence, and the arrest warrant has 2855 Germain, where did the court get that address from?
Isn't that where the incident took place?
Correct.
Okay,
Where did he
but-
get
but-
that address? It was not because, and I don't believe in my experience that where a crime occurs is where they put the address of the defendant or the suspect. It's either asking the defendant or the suspect, where do you live, or you have their driver's license. The record is absent as to where the officer got the address in the arrest warrant. I don't even know if it was this Officer Green that entered the arrest or took the initial report for the domestic violence case, but we can, I just...
Counsel, I have a question.
Yes.
First off, good afternoon. And I want to follow up on Justice Markman's question. Does the law permit someone to live in 2 separate or 3 separate locations?
I'd say yes. You can think of a person has maybe a primary home and they may have a vacation home that they live at or reside at, maybe during the summer months or the winter months. For instance, my mother, my family's from Central America. She goes there during the winter time. Does that mean her address is in Central America or is it in Michigan?
But counsel, is there any case law that kind of goes into this in
I-
terms
there-
of you can live in different places and what constitutes that idea that Justice Markman was going to about living at an address?
There is a case law regarding that, and I believe that Mr. Van Hoek did refer to that in his brief, and I can't recall that right now, but there are definitions regarding domicile and residence. And if the court wishes that we can, I can file a supplemental brief regarding those definitions and how those apply in this case.
Is it completely unrelated to the officer's reasonable belief that it seems, at least as far as I know to be the facts here, that there is zero evidence that the defendant ever in fact lived at his mother's home, at least since he became emancipated? There's no evidence of that having happened for even a single day.
I could say no because, again, he's been at that house before. His address is listed as that address in the arrest warrant.
So what inferences can be drawn from the fact that somebody has been at another's house? Let's go further. Let's assume the relationship that we have here, a son to his mother. What inferences can we draw from the fact that we know nothing other than the son has been at the mother's house on at least several occasions? Can we draw the inference that I suggested earlier, that maybe that indicates that he could have lived there? Or is the fact that there's no actual evidence that he ever did live there something that ought to be balanced in the equation?
You can infer from the fact that the officer's been to that address before, the fact that Mr. White was found at that address, the fact that this arrest warrant has the address on as his place of residence, can infer that he resided at 2855 Germain Drive.
Counsel, I'd like to also ask you about if you could respond to Brothers Counsel's discussion about the steps the officer could have taken to determine where the defendant actually lived. He had said it was easy for the officer to take these steps to see where this gentleman lived. Can you respond to that?
I would state that it would be unnecessary for the officer to either go to look tax records or go to some other resource to find where the Mr. White actually lived. We know that officers are overworked, that they have a lot of work to do. It would just be unnecessary, and again, it's a reasonable belief standard that the officer, what he knows, totality of the circumstances, and he had more than enough evidence to believe that this address was the defendant's son's address.
Thank you.
Thank you.
Do you have any, are there any questions for the appellant? Hearing none, the case is submitted. Thank you.
Thank you. It's a wrap.